together. Let me bring on stage Hollis, Liverpool, Chocolates. Real life. Chocolates. Especially for the mothers, all present. I see black women running from their race. They own black children they can't face. They don't know their roots as a glorious bloom. Blessed be the fruit of their womb. They just be acting as though they shape of their history. They just be proud of other people's own. They just be glad to disclose their baby's ancestry, putting their child upon a false throne, not their own. For hear them boast to their friends and their neighbor. My baby's nose from his Spanish grandfather. My grandmother married a Chinese named Lau. That is why the eye's so pretty and he has such thick eyebrows. The dimple come from my husband's side, whose great-grandfather was Irish. And watch how the eyes pretty and wide, cause my mother mixed with British. And watch at me, I'm Caribbean Portuguese, so my child here curly. But the baby black down to the eyeball, they see Africa at all, at all, at all, at all. I said the baby black like a voodoo doll, they see Africa at all. I see black women running from their race. Food from our table, they can't face. If you hear them boast about how they just make French fry and French toast with gut steak, they have a name for all them foreign foods they using. Italian pizza, they murdering. Big African wedding, they serving Spanish rice with Scotch whiskey and French wine on ice to feel nice. Chinese chowing, serving in black christening. English muffin when the son graduating. They just fry egg and call that Spanish omelette. And frying Irish potato with New Zealand butter in fed. Hungarian goulash and Irish stew is what they're preparing for lunch. They even going Honolulu to drink up the Hawaiian punch. That when they brew, they're mommy and turn cuckoo and swizzle callaloo. Or make your bone and champion roll. They don't see Africa at all, at all, at all, at all. They're making yam and as she looks small.
They don't see Africa at all.
Black people must stop running from their race and search this their place for their traits. You don't have to go by plane to Ghana in order to see Africa. Every time you come planting with mortar and pestle, or on your hand you wear your slave band, or when the Boko Jumpy walk tall amidst the people, then you rubbing shoulders with Africans. Understand what the neighbors say, how she neighbor stringberry in New York City, so that makes her a Yankee. Oh, how she love stories of Arabian Nights and boasting about her French perfume and her Turkish delights. African dashiki she won't wear, she would not even plait her hair. Stories of the Nagahu, her children them never hear. That when she husband, Mr. Paul left her last year, she run quickly for Obia. She burn and light to put blight on Paul. She ain't see Africa at all, at all, at all, at all. The Obia man gives she push back to bring back Paul.
She ain't see Africa at all.
Understand what the neighbors say, how she neighbor stringberry in New York City, so that makes her a Yankee. Oh, how she love stories of Arabian Nights and boasting about her French perfume and her Turkish delights. African dashiki she won't wear, she would not even plait her hair. Stories of the Nagahu, her children them never hear. That when she husband, Mr. Paul left her last year, she run quickly for Obia. She burn and light to put blight on Paul. She ain't see Africa
at all, at all, at all,
at all. The Obia man gives she push back to bring back Paul.
She ain't see Africa at all.
I'm going to tell you something that this is one of my favorite songs because I got away with this. True.
Good evening and welcome to Politics 101. It's Wednesday evening, and tonight we continue our conversation. Last night was quite a night. We went for 3 hours last night. the APNU people were here, and we did our thing. The mighty Choctaws there, the NC Africa Atoll, the NC Africa Atoll. As I said, it's the greatest music God has given life to, and it came from our Caribbean, and it must come from our Caribbean. Identity and recognition. Identity and recognition, those are two of the planks of the International Decade of the People of African Descent. The NC Africa at all, not identifying with their African roots, and of course, the recognition of what we Africans have given to the world. And tonight we are going to be talking about that case that we touched on last week. In fact, I think it was last week, Wednesday, when the court gave its ruling granting IDPADA-G the subvention for the budgetary year 2022, I think, and left open the issue of the reinstatement or reinstallment of the subvention itself for the following years, 23, 24, 25, and so forth. My own argument, as I said, that our court is very conservative in its jurisprudence, which can be very frustrating, you know, because Guyana signed on to the International Decade of the People of African Descent Treaty. And in taking away the subvention, you're violating the treaty that you say. I am not a lawyer, so I'm going to ask the lawyers when they come on. You know, there are two types of lawyers we in the Caribbean have. You know, they're the lawyers who practice, and we have one of them on. Dr. Williams, Vivian Williams, used to be a journalist, and he has now become a lawyer and is known for taking up these cases. And then you have the kind of lawyers who, in the old days, they used to admit them to the bar. The Guyana type of lawyers, people who actually study the law, like Vincent Alexander, and have a deep understanding of the law, but they're not practicing. And Guyana used to represent himself, and they used to admit him to the bar for the duration of his case. And so we have those two types of lawyers. So Vincent Alexander, the chairman of IDPADA-G, is here, and Dr. Williams is also here, and we're going to be talking about the case and the implications going forward. As you all remember, I did raise the matter of the International Decade during the budget debate, and I was asked to by the African constituency. I thought it is representation. I represent a constituency, and I recognize the difficulty of talking about race in a place like Guyana, talking about Africa and Africans, and although we sang on to the National Decade, we don't. And when I, as you all remember, when I raised that matter, oh Lord, they came down, and the people who were loudest in their condemnation were the Africans in the PPP. And I saw some glum faces, the Indian members of the PPP. I think they recognize it went too far. Some of them actually privately apologized to me for the behavior of their counterparts. That's what Choctaws is talking about there, you know, a kind of self-hate, you know, which Malcolm and Franz Fanon and others spoke about, you know. It wasn't Indians who were coming down on me. It wasn't Amerindians. It was Africans. And Choctaws said they ain't see Africa at all, at all, at all, at all. What to be must be. What to be must be. I maintain that we are a complex people, we are a complex region, and we have to represent that complexity. That is why I say that to understand my own politics, one has to understand left-wing radicalism, and our left-wing radicalism didn't come from Karl Marx. It coincides with Karl Marx. Our left-wing radicalism came from the plantation and coincided with Karl Marx when the Europeans were talking about socialism and so on. The Africans were talking about African socialism, and they said there's a kind of redundancy because African way of life itself is socialist. So to understand us and to understand the tradition, one has to understand left-wing radicalism fused with a Caribbean nationalism. And you all hear me on this program all the time. I am a Caribbean man. We are Caribbean people. We were that before we became Guyanese. Left-wing radicalism, Caribbean nationalism, and black nationalism. And the fusion of the three. Now you see one, now you see the other, now you see. You know, people like to isolate one. David Hines and Vincent Alexander, they do is talking about race. And they don't hear. One of them said, if Trump bombs somebody tomorrow, you would never hear it on David Hines' program because all he's doing is talking about race and so on, you know. But to understand us as a people, you have to understand the fusion of those three ideological strands. Good evening and welcome to Politics 101. I see some of you are here already. Please share the live. Please share the live. We're not going to go 3 hours tonight. We're not. Oh God, you all stayed on. Such wonderful people. And that's when we know we are in struggle. That's when we know we are moving. We're moving in struggle. Thanks to all of you who got in touch with me, email me, text me, and thanks for the clarification, you know. And that's what I think is my mentor Kwayano, who said the artists and the activists and the scholar, we are like a gardener with a watering can. You know, you're tending to the thing, taking the people's experience, refining them, and then giving them back to the people as political and cultural nourishment. That's what we are doing. Everything I try to explain, or we try to explain, is really your experiences we are taking and refining them, what we call research or study, and then giving them back to you as cultural nourishment. And that's what we attempt to do. It makes sense, you know. 1964, 2011, 2015, 2020. And you look, the PNC won those 4 elections as part of a coalition. Yes, they won the 2011 election. They won it. Because of our constitutional arrangement, they didn't take power, but they won the election along with the AFC. And in 2020, with a rigged election, a raw vote, they come within 1 seat of winning. And when you take all the anomalies and so on, you know, they clearly won that election. Are they not decided the election or raw vote? So those 4 elections, what they have in common? Coalition. Coalition. Coalition, that's what they have in common. So all those who are trying to advise the PNC, you must look for crossover vote and you must look for that. PNC always won with coalition. That is, they brought their base. They brought their base. And then UF and AFC and others, they brought the crossover. But the crossover would not make any sense if the PNC, they only bring 30% of its base, or 40%. 30 plus 5 crossover is 35. 30 plus 10 crossover is 40. But 45 plus 7 crossover is 52. The crossover only kick in when the base is there. And you wonder, all these political commentators can't figure out they didn't go to school. I don't mean it literally. They did not political, they don't have the tools of analysis. And so, they spout nonsense. When our base, part of our base deserted us, part stayed home, part voted for win, we lose and lose badly. Even if we get 15% crossover, we still would have been beaten because we couldn't get, you win an election with your base and you lose it without your base. It's basic political science. But people in this country sometimes get caught up in nonsense. Get caught up in nonsense and try to sway you. And I think some of our well-intentioned politicians on our side fall for it. After we don't get beat, Jack Dio jump and he said, Norton is a political scientist, doesn't he know that the first thing you do in elections is hold on to your base? And when a meeting in Parliament and we gaff and things, I said, but that's why I was saying we got to hold on to our base and we had to go to coalition. Two things, hold on to your base and coalition. And I say, you call me racist. As I say, I can't tell you how to tell me because you didn't give me permission. But he knew that I was correct. He knew I was correct. And so therefore I thank you all for recognizing that sometimes we have to explain these things so our people can understand. We win 4 elections. We meaning the PNC. They can quibble about 68 to 92. But the ones that the PPP didn't win and the PNC won, it was through coalition. Don't worry, them in a crossover vote. What they didn't tell you all is that Mohammed didn't bring no crossover vote. When you add E-vote with V-vote, we get 28 or 29 seats. You didn't bring no crossover vote. Crossover vote is a hard thing. Ethnic environment is a hard thing. And what they don't say is that black people didn't only vote against APNU, sorry. They vote against PPP. They vote against PPP. That is probably more devastating. But the PPP is sensible. The PPP will never put their victory in the hands of black people. They will never do that. If they get a quarter seat or a seat, they say, thank you, Jesus. But they will never stake their victory. Never. They get more sense than that. That is why the PPP has come up with the formula of holding on to your base, buying a few votes, and taking advantage of the flawed political system we have. Why do you think the PPP don't want to clean up the voters list? They get a couple of seats from it. Why do you think they don't want biometrics? They get another couple of seats. In an election where you win by 3, 4 seats, 1 seat, 2 seats, all the base, rig the flawed system, and then now come up with the vote buying thing. That's their formula. And my job is to stop the formula. I can't stop Indian people from voting PPP. I can't do that. And I think we got to be honest with ourselves. But if we clean up the voters list and we get biometrics, then we are able to take away a 2, 3, 4 seats from the PPP. That's why they don't want to go down that road. They don't want to go down that road. Good evening. I think you all are here. I kind of warming you all up because the discussion tonight is going to be on that case and IDPADA-G, very important topic for us to discuss. And I say Alexander is here, Vincent Alexander, and one of the lawyers for IDPADA-G, Dr. Vivian Williams is here. Let's start the discussion. And let me bring in Vincent. Here we go. System is giving me some trouble tonight. Let's see here. I don't understand why we're not. The system is giving us some trouble tonight. I don't understand. All right. That. Oh, there we go. There we go. All right. Good evening, gentlemen.
Good evening, David, and good evening to the listening audience.
Dr. Williams, you have to unmute. Good evening, Dr. Williams. Dr. Williams is sorting himself out. Vincent, tonight we are going to be talking about this case that has dragged down for years. As our audience knows, because they've been keyed in to the issue that when President Granger, and here is Vivian. Good evening, Dr. Williams.
Good evening, Dr. Hines. Good evening, Mr. Alexander. Good evening
Yes.
to your audience, your loyal and faithful audience.
Thank you very much. And they are loyal and faithful. Last night they were here. Oh, over 1,100 of them stayed live for 3 hours. We had the APNU parliamentary leads there. I was saying that we know that President Granger had, in recognition of the first decade of the people of African descent, had proposed a subvention which was passed by Parliament for IDPADA-G, International Decade for People of African Descent, Guyana. And when the PPP came back to office in 2020, 1 or 2 years later, they stopped that subvention. And IDPADA-G moved to the court. And as is the case with our court system, people almost forgot about that case. And I noticed the Chief Justice in our ruling apologized for the long delay and so on. You know, I think it was the fiscal year of 2022, and we're now 2026, so 4 years for an important case like this. But as old people would say, it's better late than never. Let me start off by asking both of you, and I'll start with you, Dr. Williams. Is the outcome, is the ruling of the Chief Justice, can it be considered a victory for IDPADA-G?
That's a good question to start off, and I would like to probably answer it not in the manner in which you wish I answer it. I would say the ruling is a victory for constitutional democracy. The ruling is a victory for civil society. The ruling is a victory for the ordinary man and people on the street. The case is no longer about IDPADA-G. This case is about constitutional maturity. This case is about how the government will respond to a ruling that is constitutionally significant. What it says is a very significant constitutional principle that government may have power, it may have authority, it may have the right to act in ways that are detrimental and negatively affecting institute organizations such as IDPADA-G and groups that it disagrees with, but it must do so in a procedural, fair manner. And so the issue of procedural fairness is a significant constitutional principle that the court upheld. And that constitutional principle that the court upheld in this case is one that IDPADA-G will not be the only organization benefiting from. Every organization, every individual, every group, every entity in society will benefit from it. So I will say it is a victory for Guyana and a victory for constitutional democracy.
And I'll come back to you, Dr. Williams, on that last point you made there, that it's not only IDPADA-G who will benefit from the outcome of this case, but other civil society organizations. I will come back to you on that. Let me go to Mr. Alexander and put the same question to him, and give him your initial comment. I will broaden the question. Is this a victory for IDPADA-G and the cause of the decade of the people of African descent, Vincent Alexander?
Let me answer that this way. We have a legal system which is a common law system. And not all of our laws are codified. Many of our laws are precedents. This decision could be seen in the context of the precedent, although it is not a decision of the highest court. It's still one that can be referred to in subsequent cases. And so it's in that context that we talk about it being beneficial to society at large, rather than IDPADA-G specifically. IDPADA-G undoubtedly benefits from the ruling because the government is now obligated to pay the monies for August to December 2022. But more than that, any other such matter in the future can rely on this judgment as a basis for arguing the case and realizing their rights. So it's like a subset. It's the whole set is about the precedent that has been established in our jurisprudence, in our legal system, and the body of people who in the first instance can benefit from that, but it's not restricted to us. It's something out there now for the community at large in future circumstances.
Vincent Alexander.
I would say this also educative, because it means that individual citizens and organizations now have a better understanding of what their rights are. So it's also very educative and consciousness raising.
Vincent Alexander, the chairman of IDPADA-G. Of course, Vincent wears so many hats in our country, but tonight he's wearing the hat of the chairman of the International Decade of the People of African Descent, Guyana. Vivian, Dr. Williams, let me come back to you. You know, I always, whenever I had cause to teach a court case. And as you know, political science, for the most part, is about a lot of court cases and so on. I always say to my students, pay primary attention to what is it the court was asked and what the court said, right? And so I want to put those questions to you. In this case, what is it you on behalf of IDPADA-G and the other lawyers on behalf of IDPADA-G, what is it you are asking the court? And what is it the court actually said in response?
Dr. Hines?
Yes.
Dr. Hines, I see you are very fond of the, what you usually say, beat and teach.
Yes.
And you're continuing that platform here on the internet. So a very good question. I would just add a little bit of one aspect to what you said, what the court was asked, what the court said, and how it arrived or justified what it actually says.
Perfect.
In this case, the court really was asked a simple question. If we want to make it very simple, was the government right or wrong to stop the subvention that IDPADA-G was receiving in the manner in which it did? And the manner in which it did was simply just turn the lights off. No notice, no opportunity to be heard. It turned the lights off. And the court was asked to determine whether that was right or wrong. And the court says it was. Now, in the course of having the court saying or arriving at that position that the government was wrong, in acting in the manner in which it did, we put to the court several reasoning as to why the government was wrong in acting in the manner in which it did. And there are quite a number of reasons we put forward in presenting to the court and asking the court to answer the question that the government was wrong. And one is evolving principle of law, very new in the Caribbean. It has been around for a little while, something called legitimate expectation. And it is really what it says, legitimate and expectation. What should one legitimately expect? You have a relationship with someone, you have a relationship with an entity. What do you expect in certain circumstances should apply? And of course, we have the whole natural justice principle of procedural fairness, that you were given an opportunity to be heard and that you were given notice. Because if you're given notice when you have a relationship in which you have made significant investment, we have to remember, in order to provide a service for which the government has agreed to subsidize for the benefit of the people, an entity or a citizen or an organization would have to invest significantly for that, for the delivery of that service. And investment is not something that you could just simply roll back. Some of it would have required contractual relationships that are long-term. And the whole principle of legitimate expectation and the procedural fairness of it, the substantive fairness of it, requires consideration of all of that. And so we introduced the principle of legitimate expectation, which is only recently, within the last decade or so, received significant attention at the level of the CCJ. In fact, in one case, the CCJ introduced the principle even where the lawyers didn't raise the principle in ruling in a particular way. But we also recognize that this expectation of fairness is annexed to a stronger and even more significant principle rooted in our constitutional democracy, and that is natural justice, fairness. The court held on that principle. The court moored its ruling to the whole idea that there must be procedural fairness in the way the government acts. It may have a right to do a thing, it may have a right not to do a thing, but then there must be a particular procedure that has the elements of fairness in reaching that decision to do or not to do.
Vincent, I want you to come in here because we have an executive and by extension a legislative branch, because the executive party in the executive controls the legislative branch, that seems to have a penchant for abusing the letter of the law. The letter of the law. And we have a court architecture or culture of jurisprudence that itself tends to, in my estimation, over-rely on the letter of the law. And as I was listening to Dr. Williams there, in which he said the government may have a right, but what is also important is how it administers that right, which goes beyond letter and begins to wander into the spirit. Is law, especially in a contentious society like ours, can the law continue to be just grounded in mostly the spirit, the letter, and not quote unquote the spirit? You talked about common law in your introduction. So I think you yourself, your very opening statement begins to wander beyond letter. Talk to us about spirit and letter, and how that advances rights in Guyana, or contracts right.
All right, so that indeed laws have what is referred to as a letter, that is a literary, simple interpretation of what the words intend. But those laws are made against the background of a history and in a context. And one can derive from the background and the context the spirit which is reduced to writing. Now, so when we talk about legitimate expectation, IDPADA-G from the year 2018 to 2022 got a subvention from the government. We got a subvention. There's no question about that. That established the spirit of the relationship with the government, and therefore lends to an expectation that we will continue to get that subvention, and more particularly in the year in question, because in the year in question, money was budgeted for that purpose. So given the history of payment, given the budgeted sum in 2022, one can have no other expectation other than the money will be paid. And there are other things that lends to that expectation. The said government, in facilitating the payment, ordered the Bank of Guyana to open an account. So these people are going to be getting money. So let's have an account into which the money could be paid. The minister, in his submission, admitted that IDPADA-G was a subvention agency. In other words, in the legal architecture and the administrative arrangements, the government saw us as a subvention agency. What is a subvention agency? An agency that gets a subvention from the state once you're annexed in the law. So all the conditions there are conditions that suggest that not only is there some written something, but there is also a contextual and historical framework which points to what one could and should expect. So the spirit very much provided for, and the law in its interpretation does not ignore the spirit. It takes into consideration the spirit. So, for example, it asks the question, what was the intention of the drafters of the law? What did they intend? Now, that's not written anywhere. That's in a sense, is a part of the spirit of the law. And certainly in this instance, the state, by virtue of the things that it did, one, to give us a subvention from 2018 to 2022, to provide to us our bank account to receive those monies, to consider us to be a subvention agency, did set up the expectation, and probably more than the expectation, the obligation to pay those monies to us.
Vincent Alexander, chairman of IDPADA-G there, addressing the issue of the letter and the spirit of the law. Dr. Williams, if you have anything to add to what Vincent said there, please feel free to do it, but I want...
Well,
go right ahead.
The question is a very rich one. And the spirit of a thing really dictates the substance of it. The letter of the law is not written in isolation. They are not just simply words. They are written, the substance exists in order to be able to realize the spirit, the intent. In essence, what the law exists, what is the purpose of the law? And so when you're trying to interpret constitutional law, you look at really, unless the law expressly, unequivocally, and clearly states a particular course that one should take, that you always try to, if you have to give an interpretation, you try to ensure that the interpretation that you give to the letter of the law doesn't stray from the spirit of the law. And so wherever there is some level of room for discretion and interpretation, the spirit is a significant guide as to how you should interpret the thing. And that is why sometimes when constitutional courts review constitutional matters, they will say that this interpretation will give rise to a perverse outcome. The outcome is so removed, so repugnant to the spirit, that which you set out to achieve, that the constitutional court will say we cannot consider that the legislature or the framers of the Constitution intended that the law should operate in this particular manner. And we come back to this IDPADA-G situation, and you think of it in terms of practical terms and layman terms. Now imagine I come to you and say, I need you to be my supplier, a primary vendor for a major venture, a national venture that spreads across 10 administrative regions of the country. It means that you have to provide that, and I want you to deliver the service. I want you to realize this thing that we recognize is of national value. Now, to construct a national delivery service, even if just simply to give money, we know it's very expensive. So you have to create a very elaborate and sustained infrastructure. Now you go and you invest your time, you put a lot of things aside, and you invest resources into constructing this national platform to deliver a service in the interest of the nation. In order to do that, you have subcontractors, you employ people, you write contracts, and you do all of that. And you do that with the expectation that the arrangement that you have will last for 10 years, right? A certain number of years. And then after you do all of that, I come to you on the 29th day of a particular month, and I just simply say, we done. I don't need you anymore. I'm not obligated to do business with you. I've decided that I will do business elsewhere. And that's the end of it. I didn't consider the fairness of the fact that you were delivering something I asked you to deliver. And I give you the assurance that you would deliver this for that your investment in developing this infrastructure would be for a particular period of time, and that was the basis upon which you negotiated and you formed relations with others. When you think of that, that is not fairness, and that basically is taking the letter of the law and applying it in a way that is unjust and is unfair. Anyone will say you can't do that, right? It's not fair. It's not the way. So it's the whole question is, even if the government found dissatisfaction with a civic entity, someone who comes forward and say, yes, we will help to provide this thing of national significance, and you don't like it, you call the person in. It's sort of what you call in law an order to show cause. Show cause why we should not end this thing, or give the person, taking into consideration all of the investment that the person, the entity would have made, reasonable time. We have to go our separate ways. We don't think this will work. We're going to give you 6 months or 3 months or whatever the case may be. We could talk about what is fair, okay? And then you wrap it up. But you don't just simply clap your hands and say, just get your things and go. So I think the issue of the substance comes right back to fairness and the spirit of the society that we seek to have. And that's why when IDPADA-G held its press conference, it stressed the idea of constitutional maturity.
Dr. Vivian Williams here giving us some schooling here tonight, along with Vincent Alexander, on the consequences, if you will, of the case brought by IDPADA-G against the government of Guyana, and to which the court has added its voice. The picture you're seeing there on screen is, I think it goes back to 2016, Vincent will remind me. President Granger had just announced the subvention, and he came off the stage, and Vincent and I and Sister Kamika Johnson, members of Coffee 250, and he came off, and I can say what he told us. And he basically told us that, well, I have made the announcement. It's up to you all. Typical Granger fashion, up to you all to make it work. And in a sense, gave us that responsibility. People who may ask, how did Vincent become the chairman of IDPADA-G? Well, he was elected, among other things, but as Granger made his decision, he came off the stage. He basically said to us that it's now over to you all. Just a little bit of pictorial history there, if you will, and it is significant. Vincent, you remember that moment?
Oh, I very, very much remember the moment. He came off the stage, he stopped in front of us, and he said to us, we've got to make it happen.
Yes.
And he was referring to ensuring that the African Guyanese community had a mechanism for the realization of the goals of the decade. And what we did immediately, as you said, we were more or less of Coffee 250. We went back to Coffee 250 and said, look, the president has urged us to get this thing done, and it cannot be simply about Coffee 250.
Yes.
He had addressed the African Guyanese community, although the forum was a Coffee 250 forum. And he had challenged the African Guyanese community. And so what we said there and then is that we have to go to the community and give leadership to the process. And we immediately brought together 17 organizations from the African Guidance community to discuss how we'd establish the mechanism. And we spent approximately 1 year plus discussing so we can have consensus and agreement on the mechanism which we would establish. And when we would have completed that process, that is largely in 2017, we reported to Granger that we had now completed the process, the mechanism was in place, and therefore we expected him to fulfill his commitment by granting the subvention. By that time, we had gotten to over 30-something African Guyanese organizations, and eventually we grew to 65 African Guyanese organizations. So the expectation was not narrowed to Coffee 250 or to the two of us. The expectation was for the entire African Guyanese community, because he made that promise to the community and mandated us to make sure that the promise, the basis for realizing the mechanism was put in place.
Vincent, given their very important information, because often we think these things just arise. Just very importantly, as Vincent said there, I had forgotten that part of it, that we went back to Coffee 250. And we said, well, this wasn't Coffee 250 story. This is Black people's story. We have to go to the community. And the people in Coffee 250 said, okay, we agree with that. And we broadened it beyond. And I think that was a demonstration of commitment and interpretation of what the president meant when he said, you all gotta make it happen. We could have interpreted narrowly and said that he's telling me and Vincent and Kamika is the three I gotta make it happen, or Coffee 250. But the interpretation of what he said was very important there in getting us to where we are. Vincent, I'm going to
say... In fact, let me just expand a wee bit. In fact, because it was a Coffee 250 forum and he's spoken to us, somebody had to initiate.
Yes.
And so we initiated. Coffee 250 gave me the mandate to bring the groups together. And so I became a kind of a coordinator, one among equals in the process of establishing IDPADA-G. Establishing it means that we also wrote up a constitution. It is when that constitution was finished that we held an election where we had 38 groups present at the Racket Center in December of 2017. And on that occasion, I was unanimously elected to be the chairperson of IDPADA-G. Unanimously elected, no organization dissented.
And very important piece of information. Vincent, let me stay with you, because part of what the government did was to give the impression that, first of all, it was plenty money, and second, that this money was given to IDPADA-G to share out to the community, and that IDPADA-G wasn't sharing all this money to the community, that they were using it, the officials were using it for themselves. And I think part of the battle was beating back that kind of thing. Tell us what the subvention, and it's repetitive, but sometimes you have to repeat these things. And I think it's important for the legal engagement that we clarify for the public what is it the money was used for. Sorry.
First of all, let me say that the president himself said to us he wanted us to establish a mechanism for the realization of the goals of the decade. He didn't say he wanted us to share out money. He said he wants us to establish a mechanism for the realization of the goals of the decade. The goals of the decade in the Declaration of the UN are tied to institutional reformation and legal reformation, with equity being a mechanism for realizing the recognition, justice, and development of the people of African descent. So Clearly, we were mandated to establish a mechanism that would work towards institutional and legal changes in the interest of the people of African descent. Now, these words sometimes don't resonate easily with people, institutional and legal. So let me give examples. From an institutional perspective, we saw that the introduction of history in the schools would be one way to enable the recognition of people of African descent, because they themselves would become knowledgeable of their history and who they are, as much as other Guyanese will become knowledgeable and therefore recognize them for who they are. That's an institutional arrangement. The question of the state of lands of African Guyanese, where the lands needed rehabilitation. An institutional arrangement there is to get the government to put in place a program for the rehabilitation of those lands. And so one could see the RAID project in that context. So that we had a task to interface with the community in terms of the things they needed from an institutional perspective and from a legal perspective, and to advocate with the government for those things, and to do as much as we could do in the realization of those things. So how did we start off? We started off by holding nationwide conferences where we brought the people of African descent together and said to them, hey, we know that you have had problems with entrepreneurship, whether it's funding, whether it's the legal framework, etc. We are going to empower you by giving you the knowledge of how you can go about getting involved in business. And so we held conferences across the country in the African Guyanese community, where we brought GRA to them, we brought NIS to them, we brought the banks to them, we brought the new Guyana Marketing Corporation to them, so that they could understand the environment in which they can then pursue their development. And we would then argue with the government that there are other mechanisms that they should put in place to enable them getting involved in business. So, for example, we had something called Investor-Ton, where we invited young entrepreneurs to come forward with their products, manufacturers and so. And they competed and they got a prize, money prize. But what we also did was to train them about the development of enterprise. How do you account? How do you forecast? How do you market? To train them in those things. And we held more than one investor-ton. And the prizes were as large as $500,000 for the winner, if I'm not mistaken. We also held a business expo, where we brought together, again, young entrepreneurs, and they were virtually involved in selling their business online, streaming the selling of their business, so that people would know that they have business and would be able to access their business. So we had that as well. We organized market days and exhibitions in Main Street, where we brought together literally hundreds of African Guyanese who were involved in craft production and so, to exhibit their stuff. But we did not only do that, we also involved in training them in marketing, in packaging, etc. Now, what you could discern from what I'm saying is that a lot of the money we had to spend was not just to disburse money to people, was to have the human resource that could organize and do those things which I referred to.
Yes.
And so those jokers who ask us about how much money the African community get, they are residing in a state of ignorance. Our job was not just to give money. Our job was to empower people so that they can come involved in sustainable development activities. And so we established a mechanism, the center of which was a secretariat that was mandate with people who could do the training, who could do the organizing. For example, if a group wanted to get involved in a project, they could come to our secretariat and we would write up the project document with them. So a lot of our expenditure was in the manpower aspect, ensuring that we could reach out and do what was necessary to enable recognition, justice, and development for the people of African descent. And in that regard, those of us who were volunteers did not get any of the money, because that's another thing the jokers are out there saying. And the Jagdeo case speaks to that. We didn't have it, we were volunteers. It is the staff, the professional staff, who were doing the hard work, who were paid to do the hard work which enabled the development of our communities by sharing with them even technology. So for example, we had a project eventually where we got some money from the Inter-American Fund to finance organizations. And we have financed 19 organizations, and that was post the suspension of our subvention. But we didn't just simply finance these organizations to do projects. They had to develop the project documents. We worked with them. We got manpower to work with them to develop the project documents. The projects were in agri-processing, and so we actually brought in people to teach them agri-processing, to teach them accounting for their projects and things like that. And that's the way in which, in the main, we expended our funds. There are some instances where we lended assistance to people who were in dire need. So we have a few law students who we assisted because they wanted to go and do law at UWoden. So we did that. But we also established in the 2020 a special fund to give the groups to do little projects of emancipation. Now, when you talk about $100 million a year, 65 groups, a mechanism for reaching out, training, etc., it has to be someone who is malicious to tell people that that $100 million will supply itself in cash in the communities. That person has to be malicious, as has been the case with the vice president. He did not do anything for the African Guyanese community. What we sought to do was to develop the African Guyanese community from a standpoint where they could be engaged in sustainable development projects. We sought to do things that would lend to them being recognized. We sought to do things that would ensure that justice was meted out to them. And those things were not cash handouts. Those were activities of empowerment, of engagement. Although we did, in some instances, in the latter years, each emancipation time gives small sums of money to groups to have an emancipation project. And in fact, as we speak here today, the disbursement for 2022 projects was incomplete because the subvention was stopped. So that disbursement was incomplete. And if we have to pay any money to people, those are some of the people to whom we have to make a payment. So we were an empowerment organization. It was manpower based, and so a lot of the money was spent. We have no apologies for that in requiring the manpower to do the kind of work that we were doing. For example, when they had the flood and the government officers skipped the African Guyanese community for the cash grants for the flood, we employed enumerators, spent $4 to $5 million to send people in the fields to capture the names of people who have been bypassed. And with the agreement of Minister Mustafa, Minister of Agriculture, we submitted those names so that people could be serviced. When Mustafa went to Parliament, he waved a document in the Parliament saying, look, we have done this with IDPADA-G. We have done this with IDPADA-G. He did that. Of course, Jagdeo came later on and said that the work we were doing was political work. And that's another kettle of fish. Imagine we are going out to do enumeration of people of African descent who have been bypassed in a cash grant process. And we are simply enumerating and submitting their names for consideration. And Jagdeo calls that political work.
Yeah. Vincent Alexander. And I thought, Vincent, it was important that we address that issue. Dr. Williams, I come back to you, and I want to take you two places. First, it was a revelation to me in my first couple of outings in the National Assembly. The number of organizations, civil society organizations, that are given subventions under the various ministries. The ministry that I shadow, the Ministry of Human and Social Services, they had a sum, and I asked the minister to list the organizations that subventions were given to. And there were over 15 of those organizations just in our ministry. Am I out of place to raise the issue of civil rights? I know we don't talk about it in places like Guyana and the rest of the Caribbean. They talk about it, of course, in the United States, where you do a lot of work. But in taking away the submission, was the government denying IDPADA-G a public good that others were getting? You have to unmute.
So yes, you had, so the point you're establishing here is subvention entities are very common and numerous in Guyana. It's part of the significance of the case.
Mm-hmm.
And the question is how the government deals with subvention agencies. Could it, for these 15 subvention agencies that you're talking about, wake up tomorrow and say, notwithstanding the fact that we went before Parliament, we called your name, we've been doing this for however long, here is sudden death for you, it's done, it's over. Whatever you're doing, if you have a lot of people that you employ and they have families and all of that, they're getting a salary, that it's sudden death, it's gone. And the civil rights that you're talking, these are things that are fundamentally embedded in a just society, is the idea of procedural fairness. Procedural fairness is something that protects the ordinary citizen. And I know that very often when we think of constitutional law, we think of it in the context of politics and political contest. But the essence of every constitutional judgment, particularly where it relates to the whole idea of how the state takes away that which it has given, whether what it has given is a right or a privilege, that there must be a process, a fair process by which that is terminated. And the question that you're asking is a very significant question. What is the standard? What is the standard that should apply to every other organization that should also be applied to IDPADA-G? Because, and that's where the legitimate expectation of procedural fairness comes into play. Because if you're doing this for a particular religious civic entity, if you're doing this for another cultural entity, if this is the standard of fairness by which you give and you take back, then I expect that it should apply equally to everyone. And so that's a question that you're really asking. Now, I want to mention something here that I think that, and I know you raised the issue of spirit. I think that um, this case is a demonstration of a glorious opportunity missed. One of the things that is the spirit of the decade is really to repair uh, what had broken down structurally affecting people of African descent. And when governments signed on to this noble cause, they really signed on to a reformation process. And you would think that as a responsible government, one of the claims here for that initiated the action was that, well, there were some entities dissatisfied with IDPADA-G, some Afrocentric African Guyanese organizations that made a complaint. Even though they weren't named in the court action, they couldn't be identified and all of that. Well, you would think that the government that is signaling support for this decade would say, if teeth and tongue are sort of, have the little dispute, that the government through the Ministry of Culture, which was one of the ministries responsible, will say we could help to facilitate engagement among any faction that or factions that have disagreement to help to bring about unity even within the group, to help to bring about that reformation that the decade is about, and that is the spirit of the decade, rather than to use a disagreement which is common in all society to drive a wedge and to instigate, or whether we don't want to use the word instigate, to say to cause, to nurture disagreement, and to make some little, if there really was disagreement, turn it into an ocean of conflict. And so I thought that I believe that that was a missed opportunity to show real maturity and to show that you could have state entities and institutions that are helping in the healing process and helping entities that come forward in these causes, even when the entities have weaknesses, like governments have weaknesses, like ministries have weaknesses, that the government itself could lend some technical help for greater efficiency, rather than just simply use a complaint as a means to destroy a cause so significant that you have pledged support for.
That you have pledged support for. Before I
Let,
come back to you.
let me jump in there immediately.
Yes, go right ahead, Vincent.
Indeed, there was a complaint. The Minister of Culture, Youth and Sports, based on that complaint, summoned us to a meeting, which we attended. He did not come to the meeting which he had summoned. He sent the permanent secretary with 3 questions. Those questions were, are we going to buy a building? That you can't buy a building with government funds. That was one of the questions. The other one was whether we were receiving monies as directors ourselves. And the third one was, I think, about paying the staff. We answered all 3 of those questions. We didn't have a chance of dialogue because he didn't come. And the permanent secretary was merely a postman. So she listened, made a note. On that occasion, we said to the minister, you summoned us to the meeting, you're not here. We have an ongoing interest of meeting with you to deal with these matters. We asked the PS to convey that message. He never responded to that request. Subsequently, in the course of things, we wrote him saying, look, this offense has been stopped. We don't understand what's happening. Could we meet? They never responded. So it's not a case not only of them not giving us due process, but consciously, it's not an error or a negligible act. It is a conscious act because we offered them the window of opportunity to engage us on these matters. And so my contention is that the stopping of the subvention came at an appropriate moment for a government that never really wanted us to get a subvention. And why do I say that? We went to the United Nations and we, in the course of the work of the decade, gave a status report on Guyana. The government was asked to respond to that status report. You know what's one of the things the government said in that status report? That this question of institutional and legal reformation is irrelevant to Guyana because everything is hunky-dory. And that if the African Guyanese got problems, they are the authors of their own problems.
Problems, yes.
And they gave an example. It's in black and white. They said when the enslaved Africans were freed, rather than getting involved in planting rice to make money, because there was a market for rice, they got involved in planting provision. They actually wrote that in black and white.
Yes.
And
yes.
so what they're saying, in other words, y'all got a problem, is your problem. So we don't know is all this money you want in the interest of this decade, though they are the ones who sign on to the decade. And the decade is explicit about what was intended: recognition, justice, and development. And there are many areas in which recognition, justice, and development is required in Guyana. In fact, we prepared a documentation in that regard and sought to meet with President Ali, who responded to us on 4 occasions saying we will meet. And on each occasion, the meeting never occurred. But we have prepared a document looking at all the sectors in Guyana, showing the areas in which there needs to state action if we're ready to achieve recognition, justice, and development. And the UN in its declaration did say that the state should be involved because some of the things that have to be rectified can be rectified by an African Guyanese cultural group in a village. They are global issues that have to be rectified at the level of the state. Our state has refused and have consistently tried to argue that those problems don't exist because we're getting cash grant, because we're getting houses and all of that. They're not telling the people that our lands, which have been neglected, are not being developed. They're not telling people that. But they're saying that we're getting this, we're getting that. We have called in that regard for an ethnic disparity survey. We said, all right, you are saying there's no problem. We are saying there's a problem. Let's move away from this tofu. Let's do a survey, like has been done in England, that will indicate if there is or is not a problem. They haven't embraced that. We have written to the Ethnic Relations Commission calling for that survey. It's getting close to over a year, and they can't respond. The Ethnic Relations Commission has not responded. But if you check the law, the act that established Ethnic Relations Commission, one of its functions is to do research in relation to the state of the various ethnic groups. And all we are calling for is that research. Over a year, they can't respond. So that I am not convinced that it is the complaint that led to what occurred. It is, they found the moment, because when they first stopped the subvention, it was stopped immediately after the Coffee 250 symposium, which spoke to the question of Guyana, an emerging apartheid state. Coffee 250 was holding a symposium, And Jagio came on and said, in non-equivocal terms, that we are biting the hand that's feeding us by accusing them of having an emerging apartheid state. And that's the moment they used to justify the subvention. They weren't appeasing the people who appealed to them. In fact, they told those people that you're entitled to this money, so you're going to get it. And in 2023, they gave $1 million subvention to those 65 groups. Now, I don't know what $1 million could really do in terms of addressing the issues, but they gave them $1 million each with no mechanism for them to account, but accusing us of not accounting. In 2023, what happened in 2024? What happened in 2025? Not a cent was given to those organizations. So there's no real commitment. There's no sincerity about addressing the decade.
I want to come back to you, Dr. Williams. Before I do, let me just say thank you to all those who have worked with IDPADA-G over the years to realize the objectives. I sometimes went into IDPADA-G's office after the subvention was removed and saw those ladies there still coming to work and still not knowing where the salaries could be paid and so forth. And often we see the leaders and but those who are working, what Vincent refers to as the manpower, we often don't sit and just want to say thanks to those people on behalf of our community. Secondly,
David, a big thanks to our Chief Executive Officer.
Yes, I was
professional officer who was the head of the paid staff, who has continued to work voluntarily after the suspension, demonstrating a commitment to the cause. And we really have to give thanks to her for her continued leadership. And I dare say sometimes her own financial contribution to keep our doors open.
Yes, Sister Olive Sampson. I've known Olive decades. I first came into close contact with her in 1991 in Washington, D.C., when she organized the conference celebrating Guyana's 25th independence anniversary. We just do 60. So it's 35 years, and she was a live wire in the Washington D.C. Guyanese community. There was a women's organization called Guyade and so on. So she brought to IDPADA-G a wealth of community and other professional experience to the job, and I dare say that she has continued to work assiduously and keeping the dream alive, to quote from Dr. King. I know, Vincent, you have your story on, and you haven't given me my ticket yet. CARICOM Day, the Burnham Foundation has its brunch, annual brunch, and those of you who wish to secure your ticket, you can contact the mega ticket seller. Vincent Alexander has made it a science of how you sell tickets for this event. But that's next Monday, CARICOM Day, the Burnham Foundation annual brunch. Vincent, is there a number people can call for tickets?
David, we don't have very many tickets remaining at the center. They could however call my number 709-8487. There are a few tickets still available. You need to advise me how many I should put aside for you. If that would include one for Freddie Kissoon.
Freddie Kissoon used to be my brunch partner back in the David, I can't go there. All them black people are going to want to know why you get. I don't say they're waiting on you. I ain't going in there without you. My friend Freddie. And on CARICOM Day in the morning at 10 o'clock at Buxton, Camps TV and Kidaki Amsterdam are calling a protest against the proposed bill for the benefits of ex-presidents, the benefits of ex-presidents bill, which is a contentious bill, and Camps TV and Kidaki Amsterdam, with support from the WPA, is calling a protest. And where people can't come to Buxton, we're asking them to do their own protests in their communities if it's possible. That's on Tuesday. That's on Monday, CARICOM Day at 10 o'clock. So you go to Buxton, protest, and then you go to South at the Burnham Foundation annual brunch. Dr. Williams, let me come back to you. And before, oh Lord, one thing they will kill me. Those of you who have been making your contributions to Politics 101, I want to thank you. I promised that I needed to put together a list of people who've continued to make their contributions over the last couple of months, and I haven't been able to thank you. But I can assure you that I was about to let my helper go because I didn't have the funds in order to keep the helper on, and your contributions made it possible for us to keep the help. And as you notice, we have expanded beyond the show that we do here. We do do reports and so forth, and the helper has been really a godsend. And so thank you for your contributions, and those of you who have been delinquent, please, your contributions so that we can keep Politics 101 alive. Now, Dr. Williams, I come back to you and I come back to the law. The court said that they could not compel the government to pay the subvention beyond 2022. And that IDPADA-G had no contractual arrangement with the government, and I suppose contract law and all kind of thing come in there. But I've been toying in my head and outside my head with the whole idea that the government is a signatory, as Vincent mentioned, and that you mentioned, a signatory to the United Nations Convention, recognizing the International Decade for the People of African Descent, the first decade and now the second decade. Am I presumptuous? Am I out of place for thinking that because of it's a signatory to what I'm calling a treaty instrument, does that not compel them to continue the contribution or something resembling the contribution? You have to unmute.
Right. Again, that's a very interesting question, and I think it should be answered honestly, because we're talking about principles of law. The court did, I would say, touch upon this a little bit. One may say dance around it. And the way the court framed this is to say that the government gave a commitment to a cause. And if we frame the action on the basis of the government's sort of signing any treaty or signing on to the UN cause, I don't think that in essence helps to strengthen a case that IDPADA-G as a specific entity has an entitlement, because you're not establishing from the treaty itself, from this international arrangement that the government signed, that it committed to a specific organization. The way we framed it and where we think that it is of significance is this, that the government committed itself internationally to provide a certain service, a certain product, you may say, to the people of Guyana. And then the government came back and recognized one of the significant things about the August moment of President Granger is that he recognized that the commitment that the government had made to the UN was not one that government and its various arms, agencies, and entities were best positioned to provide. And so what it did, it outsourced it. It found a contractor and say, and I think you mentioned it earlier, and say, you are best positioned to provide this which we have promised to produce. It's like, I make a commitment to do a thing, but I can't do it, and I recognize that I have to turn to someone else. The government turned to IDPADA-G, and IDPADA-G then, as an entity that the government relied on, upon a commitment by the government that the government will provide the subvention, which is the financial support that IDPADA-G needed, that IDPADA-G structured itself and structured its investment and its mobilization of human and other resources in order to provide this valuable national product. I think that is where the commitment and that is where the strength of it lies. That the government didn't just simply sign on to a cause, that it, one could say, recruit a specific entity and urge that entity with a commitment of subvention to provide it. And I think that the strength of the point that you are making lies in the value of the thing that the entity was providing.
That's it.
Right? It wasn't a casual, ordinary thing. It was something of immense significance. And when you recruit someone to provide this thing that the nation and the government has agreed, the state has agreed, is of significant national importance and value, you couldn't then just simply say, get out the place. I think that's the way we need to look at it, that the government gave a commitment from a standpoint of law, and as IDPADA-G indicated in its statement, that though we don't at this point in time want to get into the whole issue of the disagreements with the court, but focus more on the obedience of the order of the court, that we have some disagreements, strong disagreements, I think Mr. Alexander pointed out in his statement at the press conference, with some of the reasoning of the court and the manner in which the court sort of restricted it. And one of the areas that I think that is important for constitutional scholars and for activists who are interested in a strong constitution and a strong adherence to constitutional principle is this. The court found that the procedure, the manner, the failure of procedure in arriving at the decision to stop the subvention was wrong and bad in law. Well, the question then becomes, if the process that produced the decision is bad in law, then does the decision stand? And if the decision doesn't stand, then don't you revert to status quo?
Right. Right.
And if you revert to status quo has taken us beyond 2022. And so one could, from a constitutional and a strict legal standpoint, you would say that where there is failure to follow constitutional due process and fairness, that we couldn't agree that that has occurred while at the same time preserving the fruit of that unfairness, that unconstitutionality. So that's one way to look at it. The other thing is because the aggrieved citizen, the aggrieved entity, until the decision is properly arrived at, has a fair expectation that the decision would be reversed and that the status quo will govern. And this brings us to a point that it pains me to make, but I think that as we are discussing a case of such great significance, that one should be honest and mention is the duration of the time that it took for the decision to be delivered. You see, as a society founded on democracy and constitutional principles, matters of this nature really should be decided within months. And that is to say, to be heard and decided within months. The hearing on the case and the submissions were completed in June of 2023, and we got a decision in June of 2026. Now, if the decision had come in within 6 months, then this question of the status quo and all of that would not have been relevant. And so we have to begin to, as a society, to say, they say justice delayed is justice denied. We have to be concerned about the functioning of the judicial branch of government in terms of its efficiency. And we have to recognize, and even today we saw that judges were sworn in, that the judiciary must be given the capacity to ensure that justice is not delayed so significantly that its ultimate delivery may still resemble the denial of justice. And I think that it is worthy, it's important to note that it would have been a good thing if the decision was arrived at much sooner, but that would require a more robust judiciary with more assets and resources to be able to decide these matters very quickly. And so advocates for justice must also advocate that the judiciary has the capacity not to have justice delayed for so long.
Are there credible grounds for the government to appeal this decision?
I would hope that the government focuses on obedience with the order of the court and recognize the significance of its failing to adhere to the most valuable principle of fairness and due process. I think it would regret if it were to seek to appeal the decision. We believe that the breadth of an order and a decision against it, if appealed, would be greater. We believe that there has been such great constitutional value to society already derived from the case that constitutional maturity should allow the parties, both sides, to recognize that a wrong that commenced 4 years ago in 2022, time has come for the parties to move on and abide by the order of the court, which restore at least some semblance of fairness.
Vincent, let me come back to you as we wind down. Last week on this program, Takumo Ogunsi, who confessed that he knows very little about formal law and so, but he was loud in his questioning as to whether the executive will obey the court, and Dr. Williams talked about obedience, obedience there, and he kept hammering away at that point, and I in the course of the program gave a formal answer that there's, once the court makes a ruling, the court doesn't have a wild cane in which it beats the executive. The executive is the implementation branch. But after the program, I kept turning it over in my head, and I was thinking that Ogunse was onto something, given the political culture in Guyana and the way in which the state finds himself in collision with civil society and citizens organization. You go back to the teacher strike a year and some months ago, and the way in which the court really fought the teachers, and the way in which the court disobeyed Justice Kisoon in many ways. Is Ogunse on to something? And while you're answering that, have you all gotten any signal from the government that it's ready to do what Dr. Williams is suggesting that it should do?
We don't have a signal. Ogunse has a great understanding of the political landscape in this country. And I think his disposition is based on that understanding. So I appreciate his disposition. But I want to say this, that this government, when necessary, has been responsive to the international environment, international pressure. That this matter, particular matter, is not simply a local issue. It falls within the rubric of the whole issue of reparations, which the government is now there saying that they agree with, and the national decade, which is beyond Guyana. When they took away the subvention, in that context, as I said earlier, they paid our organizations, they gave our organizations $1 million in 2023 each. They then used that to go to the UN to say that they're demonstrating their commitment to the decade by giving the organizations that money. So the point I'm trying to make is that they are aware of the international environment in which they're operating, and when they can't help it, they are responsive so that their rhetoric about good governance and other things could find cleavage beyond Guyana. And so I am looking at this matter from that perspective. It's not only a matter of the local situation. It's a matter of a decade which involves the UN Declaration that we have signed on to twice, first and second decade. A decade which requires us to periodically go to the UN and report on the situation, and the fact that they've been going and reporting, then they may well find themselves in a difficult situation, particularly in relation to the judgment. There's a judgment. They may well find themselves in a difficult situation, which they may seek to cloud out by making the paper.
Vivian, as we close out and get your final thoughts on thing, as a question that I always wanted to ask you, when I knew you as a young man, you were a journalist, as we say in Ghana, a reporter, and I know you do some of that. I know Caribbean tea. You do some of that now. But how was your experience as a journalist? Help your understanding and your praxis of the law?
You know, life is a journey, and I'd like to say that when we embark on that journey, we must ensure that we take a course that whatever dust and whatever we gather along a way to a particular milestone is valuable and reusable as you move towards another milestone. So when you get to uh, accumulation of various milestones, it is really an accumulation of a wealth of experience and a wealth of knowledge, acting and serving cohesively with some synergy that help you along, that they're not fragmented and useless. And my experience in uh, in my professional journey is one such. You might not know it, but I started as a teacher. I was a teacher for several years, trained class one, grade one. So that's how I started, and that provided a foundation of interacting and engaging in with the community in the form of education, and that then gave rise to another way of speaking to uh, problems, ills, and concerns in the society through a journalist or journalism. And I think that the path or the journey as a journalist was one where one acts as a recorder and an amplifier of the concerns and the problems of people, societies, and institutions. And law takes it to a different level. Law is where you are not just simply an observer of these circumstances, but you jump into the ring as a reformer, as a means to be able to change that which you have observed. And so I would say at this point in the journey, I am not just simply one who observe, document, and amplify through this dissemination the concerns, problems, and ills of society, but one who is now taking it a step forward to be able to provide meaningful reform and help. So they are complementary, I should say.
And you know you take on these big social cause cases. And we in Guyana have a rich tradition of that. I mean, some of the luminaries have been people who have taken on these cases. I like to say, when I was a young man, became a political activist, I had two lawyers, Peter Britton and Benji Gibson. Me alone had two lawyers. And they were both well known. I mean, Peter Britton can be considered a luminary. And I remember Peter used to say to me, I am your lawyer. And all I ask him, if you want to, when you become famous, let them know that I was your lawyer. And people today mourn the fact that we don't have too many lawyers who are taking on these social causes. Brother Nigel Hughes looms large, and I think he was connected with this case. We see Brother Dexter Todd now stepping into that mold, and of course yourself taking on. I know you were connected with the Mokard Cater case and the case of the people with the Demerara Harbor Bridge, which I was involved with at some level. What drove you in that direction?
Well, I'd like to say that those are the best cases to take on, because as a lawyer, you never lose. The as a lawyer, you never lose in this case, because one of the things that we must recognize about constitutional litigation is that today's loser is tomorrow's beneficiary, tomorrow's winner, because governments change, situations change, and those who stand at one side of the table, one side of things today, may find themselves on the other side. And so whatever principle you help the court to shape and to fashion, even if the court rules against that which you seek, it will shape and help to interpret the Constitution in a way that tomorrow you will be the beneficiary of what the other side claim as a victory. So when you take on these cases, really what you do, even when a ruling is not in your favor, you would have struck a blow for the betterment of society, and therefore you would be part and could be considered a winner. So, we're all winners in this. So I think that these are matters that are essential to really help the maturing of the country. We must also remember that Ghana is still a very young nation when we think about other constitutional democracies. To in large respect, the Constitution is now settling. And even when we talk about constitutional reform, we also have to remember, like a great foundation, it takes time for it to settle. And when it settles, that's when the full value of it is appreciated. And constitutional litigation helps in the settling of the Constitution. And so that the society then rests on a stronger foundation, however it is that it is interpreted. Because even when the interpretation is not to the satisfaction of society, and you recognize that the rulings are not within the spirit that we talk about, then you could go back and have reform. But how could you reform constitutional provisions when the courts, the highest courts, and the issues have not percolated in a way that you could say that here is a settled principle that we dislike?
Dr. Vivian Williams, lawyer, former school teacher, and reporter / journalist. Well put. Vincent, you have the last word. You did say at the press conference that basically it's $32,000.
32 million.
32 million, sorry. 32,000. $32 million is the money part of the ruling. IDPADA-G still has its doors open. What now?
Well, as I said, IDPADA-G's doors are still open. We have managed to keep those doors open from 2022 to present. And in that vein, we continue to do our work based on contributions from individuals, companies, and even grant agencies. So that's our intention, to, within the means at our disposal, to continue to pursue the objective of the decade. We are indebted to lots of people who have made significant contributions to keep the doors open. And I would like to take the opportunity specifically to express our gratitude to Nigel and Vivian for the work they have done in this particular matter. That too has been a contribution to IDPADA-G. And I want you to note this. You have referred repeatedly to Vivian as Dr. Vivian Williams, which is correct. But you got doctors and doctors.
Yes.
Vivian is not merely Dr. Vivian Williams. Vivian is someone who has a PhD. So he has an academic award for a doctorate. He doesn't have an honorary award. So you can't put him in the category of other people who got doctor in front of the name. This really shouldn't be using. But more than that, Vivian's modesty did not let you know that his scope has not been restricted to journalism and to law. He's also a management expert. And if I'm not mistaken, and he could correct me if I'm wrong, his PhD might well be in management rather than in law.
Vincent Alexander, is it in management, Vivian?
Well, it's in sort of management and business development, international business, and that kind of thing.
What we call the grounded and rounded Caribbean person, as we must. Good evening to you, Ron Delane. Good evening to some of you who I am seeing here. I know over the last couple of minutes, a couple of you have sent in your contribution. please do. I sometimes forget to beg, and it's not because we're rich. It's just that sometimes when we come before the cameras, we focus on that. But please send in your contribution, and remember on Monday at 10 o'clock in Buxton, the protests against the ex-president's benefits bill come out to Church of God Road on Monday morning at 10 o'clock. Organized by Camps TV, Buxton, Guyana Morning Time, Kedaki, Amsterdam, with support from the WP. And in the afternoon, there is the Burnham Foundation annual brunch, and it's a big to-do. You see Vincent with his short pants running up and down, and so on. You see in another mode as chief organizer there. It's always a good line. And Vincent is being held at the Burnham Foundation's office
in Palm Road,
right.
South Fell Garden.
South and Fell Garden. So go down there. Tickets, I know, go very quickly, and often when you're a late man like me, you go and you saying Vincent's got me ticket, and something you gotta wait. Vincent gone and collect Pourier, gone and collect be there, and you gotta wait till he come back and that kind of thing. But go down there, even if they don't have ticket, they will have food and drinks, so you can be rest assured of that. Gentlemen, thank you all so much for coming on, and as usual, I think that was what McAndrew used to say, we get learning, we get education, and we get knowledge. Well, he never used to say education. We get learning, we get education, and we get knowledge. And I think that is part of what we aspire to do here. Thank you all very much, and we will keep on top of these developments. And hopefully, when we come back, it would be to announce even better news than a favorable court ruling. Thank you very much, gentlemen.
Thank you very much.
Thank you.
And to you, the audience, thank you all very much. It's Wednesday night. Tomorrow night, what do we have tomorrow night? But we have something tomorrow night. So I will see you all tomorrow night. Please, your contributions. As we say, we are what we are. And that's the way it's going to be.